Hi, my name is Trisha. I am an HR representative and I will be conducting a seminar on employee-employer rights. Ways to facilitate a liable-free work environment. Does anyone know what employment law is? Employment law is a collection of laws and rules that regulate relationships between employers and employees. Employment laws say that when an employer can hire employees and when the employees can work. The law covers what an employer must pay the employee for their work as well. They create minimum requirements for working conditions. Now, let's take a look at how you can not only protect yourself, but the company as well. Why is it important that we know labor laws as managers? Fundamentally, knowledge is power. Let's review some of the benefits. Knowing labor laws can protect the employee and the employer. It also preserves the integrity of the organization. If we know the law, it decreases the chances of managers violating the labor laws as well as employees. We as managers set the precedents. Economic stability. Violating labor laws can be a huge financial liability. It can virtually bankrupt an organization. Equal opportunity and promoting diversity. Decreasing violations and fines. Decreasing lawsuits, in turn saving the company money on lawyer and litigation fees. It will also protect the individual on a personal level if none of these crimes are committed. And last but not least, employee retention. Hiring a new employee is so expensive. When employees work in a fair, equal opportunity, non-hostile environment, they are comfortable and therefore can enjoy their job. So, who regulates this? The governing bodies that are most widely recognized is the Department of Labor. This is the biggest governing body. The Department of Labor primarily oversees wages and child labor laws. The next biggest that follows closely behind is the Equal Employment Opportunity Commission, also known as the EEOC. They regulate anti-discriminatory laws. OSHA, the Occupational Safety and Health Administration, protects employees against unsafe and unhealthy work environments. Now, there also are many other governing bodies. These are the major ones. But we as managers, as well as union representatives, arbitrators, and mediators, also have to regulate and execute labor laws. Now, for some of these laws, there are a special group of people called protected groups. These involve, to name a few, minorities, women, and men and women of color, also as well as disabled and men and women over 40. Now, does anyone know what some of these laws and acts that help to establish employment law? Perhaps the most widely recognized one is the Title VII of the Civil Rights Act. This act prohibits discrimination based on sex, color, religion, sex, national origin, and/or pregnancy discrimination. Now, pregnancy discrimination was amended later on, but it's still part of the Title VII Act as well. Now, also under discriminatory acts is the Age Discrimination Act. This act prohibits age discrimination against employees or applicants over 40. Now, the Family Medical Leave Act. This act protects employment for certain life events. If an employee has a major surgery or birth of the child, as long as the employee has been with the company for 12 months or worked 2,080 hours, then the organization must guarantee their employment upon return of an improved FMLA matter. And that's per the United States Department of Labor. Now, the American with Disabilities Act prohibits discrimination based on disabilities. Okay, the Employee Polygraph Protection Act. This states that you cannot give polygraphs to either applicants, new hires, or current employees. The Fair Labor Standards Act. This established minimum wage and overtime pay. It also has been revised more recently in certain states, saying that salary workers now have a minimum within their state that you would have to pay them if you're choosing to pay salary and not overtime pay. The Equal Pay Act. This means equal pay for men and women doing the same job at the same skill level. National Labor Relations Act, the NLRA, allows employees to join or form unions. So when an employee or a group of employees want to join a union or interested or have a union representative come to the organization, an employer cannot bribe or blackmail employees who wish to campaign or establish a union. That is against the law. So if an employee walks up to you and says, we are interested in starting a union, essentially you have to let them. It then goes through a campaign, and then the majority of employees then vote whether or not the organization will form a union. Now, one of the things I always tell managers is to protect yourself, you must refrain from high-risk behavior. High-risk behavior can include, but are not limiting to, referencing clothing, sexual orientation, referencing sex, race, and or national origin. This can also be put in the form as derogatory or slang, inappropriate work jokes, lewd gestures, fraternizing with inferiors, engaging in illegal activity, and of course favoritism. Now, mapping a complaint. There are several different ways to handle a complaint. Our first course of action is to have the employee report directly to their direct manager. The next thing they would do is the direct manager would then take it to the supervisor, given that those are the managers within their department. After it is given to either the direct manager or the supervisor, it then must be put into report form and given to human resource. So some sort of written form of what happened with the situation, and then given to human resources. It is important, no matter how small the issue is, our human resources department is trained in executing and handling matters in the appropriate manner. If a manager does not follow protocol, they could receive a corrective action up to and including termination. This is a critical point. If we do not document, it shows that we are not doing anything about the violation. We must document, and it must go through the proper protocol. Now, after the HR receives the complaint, it will then either go to arbitration mediation, because all of our employees have signed an arbitration mediation clause, or it will then be filed as a complaint through one of the governing bodies, depending on what it is. Now, depending on what happens with those and how serious the issue is, it will then go to possibly litigation. We do not ever want to go to litigation. It may cost the company thousands and hundreds of thousands and millions of dollars in finances. So we never want to go to litigation if we can help that. And by following this map, it will hopefully decrease the chances of going to litigation. Now, if an employee files a complaint, this employee is protected. Something that will not be tolerated is retaliation. If you know an employee that has voiced their rights or filed any type of complaint or investigation, Management cannot treat the employee any differently. You are not the judge and cannot condemn the employee for being a victim, possible victim. Retaliation is against the law. Now, consequences of escalated situations. So if you find yourself as the defendant to a violation, or the one being investigated for this violation, we take the law very seriously here. We have educated you on the laws that exist through employment law. So if a violation occurs, it will affect our business in one way or another. If a manager or an employee is proven to have violated any of the employee laws, they could face the following consequences. You could possibly be demoted. You could be terminated. You could be fined. You could be imprisoned. Your record may be tarnished, and for some sexual cases, an individual could be convicted and may have to register as a sex offender. And once you have some of these on your record, or once this happens to you, it's a career ending. It could end your career. So we want to make sure that you are protecting yourself. Okay. Now, know the law. Protect yourself and the company at all times. Remove yourself from high-risk situations. Report any violations immediately to Human Resources, either that you see or that you hear. Okay? Thank you so much for joining me. Have a great day, and I look forward to seeing you guys again. Thank you.